And now I have the great pleasure of turning this over to our host for the evening, who has also agreed to be an honorary co-chair of the Centennial Advisory Committee for the 19th Amendment. And I must tell you that since Jeff Rosen came here to the NCC, we have had some of the most energetic and optimistic and positive, forward-looking conversations I can remember since we got started with Vision 2020. Jeff is a great ally, he's an expert, and he has put tonight's program together specifically in the middle of our National Congress. So all of these amazing women from all over the country who are here have the great benefit of hearing from Jeff and his wonderful panelists who are going to, I'm sure, tell us many things that we need to know. So Jeff Rosen, thank you for having us.
Thank you so much, Lynn. Welcome, everyone. I can't tell you how much I've been looking forward to this evening. It was, I think, my first week on the job at the National Constitution Center last June that Lynn and Rosemary came to see me, and they said, we've got a really exciting project. We want to celebrate the 100th anniversary of the 19th Amendment in the year 2020, and we want to have panels each of the years leading up to that anniversary going forward. And I said, I can't think of anything I would rather do here at the National Constitution Center. The 19th Amendment is at the center of some of the most cutting-edge and exciting constitutional debates in this country today. Scholars are using it to rethink the meaning of gender equality and a whole range of issues at the center of national life. And the history is being re-examined, and I think we can just get together a dream team panel, the best historians and legal scholars in the country who can teach us about the history and contemporary significance of the 19th Amendment. And that is precisely what we have done tonight. We have literally the top historian and legal scholars in the country about the history and contemporary significance of the 19th Amendment, and we have a tremendous amount to learn from them. So I am thrilled to welcome all of them here tonight. A very brief word about the National Constitution Center. We are, as I love to say every time I get the chance to greet a group like this, the only institution in the country chartered by Congress to disseminate information about the US Constitution on a nonpartisan basis. And that means we bring together all sides in the constitutional debates that are riveting the country and let citizens make up their own mind. We do that in three ways. We're the Museum of We the People, and we have this beautiful space you see here that shows the inspiring show Freedom Rising. Starting next fall, we're going to display one of the 12 original copies of the Bill of Rights, Pennsylvania's copy of the Bill of Rights, and that combined with rare copies of the Declaration of Independence and the Constitution will be the basis for 3 years of debate and education about the Bill of Rights and the subsequent amendments that will lead up to the year 2020. We're also America's town hall, and that means we have debates and panels and symposia like this one, which bring together all sides of constitutional debates. And boy, these things are taking off. We have weekly constitutional podcasts on the constitutional issue of the week that bring together the leading liberal and conservative scholars in the country. The last one on affirmative action, which you can find on the web, got 30,000 downloads and just is getting a tremendous reaction. So I really think that there's a hunger around this country for constitutional education, and I hope you'll be part of it. And finally, we're a center for civic education, and we are going to create the best interactive constitution on the web with nonpartisan content keyed to the new requirement on the SAT that all students read and analyze the founding documents and the global conversation they have inspired, including the 19th Amendment. So it's now going to be crucial for every high school kid and middle school kids too who study in the Common Core to learn about the 19th Amendment and the Bill of Rights and the subsequent amendments, to be able to analyze them critically, and we want to play a crucial role in that effort. So that's the National Constitution Center. I've got a lot to learn tonight, and I'm really excited to begin this conversation. I'm going to introduce our Dream Team panelists quickly so we can jump right in. Nancy Cott, the leading historian of the 19th Amendment in the country, is the Jonathan Trumbull Professor of American History at Harvard, where her work on 19th and 20th century US history focuses on gender questions. Neil Siegel is the David W. Eichel Professor of Law and Professor of Political Science at Duke Law School and co-director of the program in public law there as well. And Reva Siegel is the Nicholas D.B. Katzenbach Professor of Law at Yale Law School, my old colleague and friend. I've learned so much from all of these scholars. That little ring reminded me to ask you to turn off your cell phones. We will have questions from the audience, and our great town hall team will be handing out note cards about halfway through the program, and you can write down your questions and we'll pose them to the panel. We're going to start with a history of the 19th Amendment and then talk about its contemporary applications. I want to begin, as is always a great thing to do, with the text. Here's my NCC pocket constitution. We'll give you some free ones if you'd like one on the way out. And here's the text of the 19th Amendment, passed by Congress on June 4th, 1919, and ratified on August 18th, 1920. It says, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have the power to enforce this article by appropriate legislation." Nancy Cott, today we think of the 19th Amendment as inevitable. No one's against the celebration of its 100th anniversary. Was it inevitable when it was passed?
Well, the passage of the 19th Amendment here in the U.S. was the culmination of an extremely long battle. Over 75 years, women had begun to agitate for the vote back in the 1840s, so it had been a very lengthy effort. And it was part of one section of what was an international push by women in many countries, the more advanced industrial countries, to share the vote with men. So I do think that at some point in the 20th century, women would have gained the vote, as they did everywhere in the industrialized world. But for instance, in France, women didn't vote till 1947. In Switzerland, it was even later, I believe. On the other hand, in Iceland, women got the vote before American women. So did women in New Zealand. So that while in one sense, yes, it was going to happen, but the fact that it happened when it did had everything to do with the kind of coalition women who were moving toward this goal were able to form in the 19-teens. And because of their move from what had been, through most of the decades of struggle, what had been a state-by-state approach to gaining the vote, given that under our federal system, the power to make people eligible for the vote does rest with the states. So women struggling for the vote had worked state by state, and it wasn't until the 19-teens that, first of all, the suffrage movement was a very, very large movement by then. It deserves the name a mass movement by the period of, say, starting just about 100 years ago, by 1914 and through to 1919, which I would not have called it a mass movement before that. But at that point, there was also a move to go the constitutional route. And I'm glad you read the text, because I think people often say casually the 19th Amendment gave women the right to vote. It really did not do that, not in a literal sense. What the 19th Amendment did was prohibit the states from limiting the vote on the basis of sex. And I want to point out the way in which that looks directly back to the Civil War and the huge shift in American society that happened by the ending of slavery and the granting of the vote to freed slaves, to freed male slaves. The push for the vote by those leaders, Elizabeth Cady Stanton and Susan B. Anthony, whose names many people do know today, really came as a result of the 13th Amendment, the amendment that ended slavery. The 13th Amendment was enormously inspiring to Americans who believed in progressive social change, because they felt in 1866, 1867, 1868, that if the institution of slavery that had been so pervasive in the American economy and had lasted for more than 200 years, if the Constitution could end something that large, meaningful, and of course exploitative, then what couldn't it do? And in the couple of years after the 13th Amendment, something like 100 amendments were introduced into Congress. One of them was an amendment to prohibit limiting the vote on account of sex. That, of course, most of the 100 weren't passed at all. But at the point at which the 19th Amendment came to seem, or a woman suffrage amendment came to seem more realistic, it was then modeled exactly on the 15th Amendment, which had been passed to try to assure against Southern former slave states' resistance that black men could vote. And it's also the model for the amendment that reduced the age level for voting that was passed in 1970, I think, 71. This negative model that the states are not allowed to limit voting on account of race, sex, or the age, the age of 21 was not to be required.
Fascinating. So Reva, Nancy, in this wonderful introduction, says that the framers of the 19th Amendment were inspired by the 13th Amendment, abolishing slavery, the 15th, which granted African Americans the right to vote. Was the right to vote the only goal of the framers of the 19th Amendment, or did they have broader goals as well?
Well, one way to look at this amendment is as a piece of federal constitutional text. But as Nancy observed, when the move for suffrage starts, it starts at the state level and has a long, many decades life as a matter of state reform. And in that time period, the question of what was at stake in enfranchising women could be said to have evolved quite significantly. You could always say, well, what was at stake was the vote. But the question is, why ever was it reasonable to exclude women from the vote? And what began to move women to seek the vote? What did they argue was at stake? And why did they think that the normal state of affairs should be disrupted and changed? And if you ask the question that way, the subject matter of the suffrage campaign runs well beyond voting to the entire conditions of daily life that might make an ordinary woman conclude that a world organized with male suffrage only was not a just world or a safe world or a desirable world and needed to change. And so a conversation about voting began to be connected to many other facets of life. And the facets of life to which voting was connected actually varied with groups of women and over time. So, for example, one very important expansion of the vote came through the women's temperance movement. The question, let me back up and just start with the world in which it's reasonable to exclude women from the vote. Maybe it's helpful even to start there. So today we think about citizenship as voting. We think about voting as the simple basis of what it means to be a citizen, but at the time of the founding and for years and years and years thereafter, voting was actually seen to be a privilege held by some and not a right held by all citizens. And we know that African Americans were disfranchised, we know that women were disfranchised, but in fact, the vote followed property for the longest time. And it took a long time before the expansion of the suffrage began to raise questions about who in the end was entitled to speak for the rest of the polity when they voted. And a long entrenched, it's sort of reasonable, for centuries, a reasonable view of the matter was that men could speak for women, the male head of household could speak for his family. And that's the structure that helps make ordinary, reasonable people agree to a world in which women are not given their own direct political voice. So then the question becomes, what might move women to challenge that order? And some of what moved some women had to do with the law of the family and the kinds of powers that were given to the male head of household relative to other members of the family as women began to want to act on their own behalf in matters of sort of economic affairs and otherwise, or wanted simply to be able to assert their voice within the family economy. Male prerogative to represent the household came to be seen by some as injury, as affront. For others, there was the question of what happened when life did not proceed according to its ideal form. And the question of drink was often that. If women were abandoned, or if their husbands were not employed, or if their husbands were taking advantage, or their husbands were abusing, the question of drinking could stand in for what does a woman need to do on her own behalf when life is not working out the way it should. There come to be other ways in which women conceive of the harm here, whether it has to do with the distribution of property or their ability to vote to protect themselves in the workplace. By the time that the suffrage comes to be a mass movement in the 19-teens, the notion of social housekeeping is an important frame for talking about enfranchisement, and that has to do with everything having to do with clean water, ability to care for children in school, conditions of women's work, their ability to have a workplace that felt safe, or a remuneration that felt fair. So you can listen to this story and see how the vote could get symbolically connected to many, many features of social life, many issues of gender justice for women that could evolve depending on one's life situation and over the decades, the sort of larger structure of politics.
Neil, tell us about the men. So in Reva's riveting history, you have a world of the Married Women Property Acts, where married women are not allowed to inherit property. They're considered, the legal subjects of their husbands and so forth. How were men persuaded to vote for the 19th Amendment? And tell us about the politics of that.
Well, there were two main arguments, right, that really were presented in opposition to women voting, and one had to do with this idea of virtual representation that Reva just spoke to, and virtual representation has a pretty shaky history in this country, right? When the colonists said no taxation without representation, the English Parliament said, well, you're represented, you're virtually represented, and that wasn't good enough, right, for the colonists and the men who declared their independence, and yet for a very long time before, during, and after the revolution and the separation from England, virtual representation was deemed by men good enough for American women. So that was one argument, virtual representation, and there were increasing ways in which women, depending on their life circumstances, were contesting this idea, that in fact they weren't so well represented by the male breadwinners, their husbands in their family. And then you heard another argument, which is actually in quite a bit of conflict with the virtual representation argument, and this was the idea of marital discord, that if you allow women the vote, that's going to cause discord, dissension within the marriage, and that couldn't be good for anyone. And of course, the solution to that was not to allow women to vote and not men, right? It was to just keep allowing men to vote. And so you can see the tension between the arguments, but both were maintained. And I think what you saw over time was these arguments becoming less and less plausible to the men who were in political power, who had the authority, right, to vote and to decide whether or not to allow women to vote. And there was also an interesting political dynamic in that once you allowed women to vote on the local level, on the state level, there was an important political sense in which there was no going back. If you advocated for the vote and you were denied it, well, then you could live to fight another day and advocate, right? But if you advocated for the vote and you prevailed, well, then you have the vote, and women are voting, and they're not going to vote against their future disenfranchisement, right? So I think part of the political structural dynamics of this was that time was, I don't think anything was inevitable. I think one of the themes I'd like to leave you folks with is the importance of history and contingency and struggle and not inevitability, right? So many things look inevitable from the standpoint of the present. There is no group organizing to oppose the celebration of the 100th anniversary of the 19th Amendment, but for the longest period of time, this was deeply contested, deeply divisive. And so I think over time, enough men became persuaded by enough women who were pushing and agitating, right, pushing for change. It didn't just happen because it was inevitable. It happened because, right, women advocated and men eventually responded. And I think it also happened because it was you could lose and fight for a future success, whereas if you won, right, it was harder once women had the vote to take it away.
Can I just add to that? One of the features of the fact that the state-by-state approach had been used was that several states, most of them in the West, began to grant women the vote. In part, these Western states were hoping to encourage women to move there. Places like Wyoming, Colorado gave women the vote in the 1890s. So by 1910, let's say, a year when a couple more states added, said women could vote, and by 1911, California did, so that some of the arguments, such as the ones Neil mentioned, that granting women the vote would mean that families would fall apart, there would be so much discord. And by 1910, there were places where women had been voting for a couple of decades, and none of those terrible results had happened. So the anti-arguments began to lose any power, because there was actual evidence that these horrible results had not occurred. And I wanted to pick up on something Reva mentioned, too, about the daily life aspects of what the vote seemed to promise to bring, or what women felt it would bring them. A lot of this was absolutely requisite for the advocacy to become a mass movement. And the way that it did had a great deal to do with the fact that immigration had greatly increased. There was a much expanded working class, and this working class, including the unmarried women in it, was being used to people factories. And there were terrible industrial conditions. The pro-suffrage advocates argued that the only way to improve conditions for women in industry was for women to have the vote and be able to vote in better laws that would put limits on the hours women could work, the conditions they could be forced to labor in, et cetera. And this was an important way of bringing not only working class women, but working class men into suffrage advocacy. And there were many middle class female reformers, the social housekeepers Reva mentioned, who also felt that the vote, having the power of the vote, was the way to bring about beneficial social reforms for pure milk and food, yes, but also very much for conditions for women in industry. So the move of women into the employed labor force was a very important factor that made the suffrage movement a mass movement. And it's quite interesting to observe, too, how far, the vote was a symbol of women's equality for many people fighting for it. It was also, after it was achieved in the 1920s, most people in the younger generation assumed that women were now completely equal and they would have complete access to all the professions, to all the learned fields, all the arenas from which they had been formerly excluded or in which they had been marginalized. Now, as we know, that it wasn't that easy, but the vote did represent a great deal more in terms of women's employability, access to education, and higher fields of aspiration in terms of their occupational lives.
Reva, take us up from the passage of the 19th Amendment to the introduction of the Equal Rights Amendment and the debate in the 1970s. I learned during our discussion before the show that the first ERA was actually introduced in 1923. Who introduced it? Why didn't it pass then? And why wasn't it until the late 60s and 70s that it really got some steam? And what's the relation between the debate over the ERA and the debate over the 19th Amendment? Just a small question for our next round.
So I'll try a short version of this. The text of the 19th Amendment refers to the suffrage, and so it actually talks about the wrongs of excluding on the basis of sex. And the question is, did it concern other areas of social life beyond the suffrage? And there were some who sought to extend the equality principle to other social domains through an equal rights amendment that would make it unlawful to exclude on the basis of sex across other social spheres. This amendment was first introduced a couple years after ratification of the 19th Amendment, and famously, the women's movement divided about whether it was a good thing to pursue an equal rights amendment at that time period, because many women in the factories were protected through forms of protective labor legislation which were articulated not just to protect workers from low wages or long hours, but to protect women from certain forms of onerous working conditions. Why that's so has its own constitutional history, which we could talk about, but I'll short circuit it for now and observe that that was then the structure of the laws. And so for some good number of women who had mobilized for the suffrage, pursuing what was seen to be formal equality by having a non-discrimination principle of the kind that the Equal Rights Amendment articulated was seen as a threat. There are really interesting questions about whether the 19th Amendment, the Equal Rights Amendment introduced at that time would have to have been interpreted that way or enforced that way. But just say for purposes of understanding this history, it was seen as if non-discrimination, sex blindness was the principle behind the Equal Rights Amendment, and there was division.
Could I ask what the text of that 1923 amendment was? Did it look like the one that came up in the 70s?
It didn't look exactly like the one that was then introduced in 1970. Actually, the amendment, as I recall, I believe it just said men and women shall have equal rights.
Wow.
Yeah. And then later, the Equal Rights Amendment that was passed but not ratified was again modeled on the 15th and the 19th. It said equality of rights shall not be denied.
On account of sex.
Yeah, on account of sex. Yeah.
You and Reva were having an interesting discussion
Yeah.
about the coalition
Yeah.
behind that 1923
Yeah.
amendment. Share that with the group.
Well, one of the really striking things about the accomplishment of the vote was the kind of coalition that was forged in the 19-teens, that for the first time, very wealthy women got interested in pushing for suffrage, which is great. It funded a lot of campaigning. But a lot of working class women also got interested for their own reasons, as I said. It was the period in which African American women were most active. There'd been a large contingent of African American men and women leaders who had been for granting the vote to women ever since the Civil War, but it was particularly became more of a movement among African Americans in the teens. And even socialists who in certain ways said they wouldn't support participation in a non-socialist government, nonetheless were for the vote for women. So it was a very big coalition of people whose interests in other respects were quite at odds. And that was, I would say, because the vote was really a tool. It was a tool that people could have to express their views for perhaps divergent goals. That is, those who supported sex-differentiated labor laws could use the vote to vote for elected officials who would support sex-differentiated labor laws. Those who thought, no, we shouldn't have laws that say, well, women can't carry 40 pounds at work, whereas men can. And they said, just let everybody go at it with the same equal playing field. They could use the vote for that purpose. So that the vote was I think, unique sort of potentiating tool and was able to gather a coalition of people whose other interests conflicted. When the Equal Rights Amendment was proposed, it was interpreted by...
Can I just
Sure.
say one thing?
Sure.
People should understand as a background fact that women as a group are obviously members of
Yeah.
other social groups,
Right.
and so it's always an historically contingent fact when they understand themselves qua women and when they understand themselves predominantly in light
Yes.
of their other religious, ethnic, racial, class, whatever identities. But what you need to understand this particular dispute is that the Supreme Court in the early 20th century adopted an understanding of the Constitution that made it very hard to enact labor protective legislation, but then carved an exception for sex-based labor legislation, the Lochner and the Muller cases. And so there was protection for women workers that was all articulated in sex-based terms. Right. And was not at that time then possible to enact it in a sex-neutral sort of way. And so when the ERA came up, it threatened that labor protective legislation, which, but for the background Supreme Court cases, wouldn't necessarily have been shaped in that form. I just wanted to
Absolutely.
give
No, that's
the
very,
context.
very clarifying. So just to cut to the chase here, the point is that equality of rights sounds more cut and dried than equal voting rights, which again gives everyone the same tool to use to their particular interests. And so the coalition that had been forged fell apart.
So this is fascinating, and Reva and Nancy have been talking about the beginning of the split between different visions of feminism, and these decisions they're referring to said you can't pass maximum hour and minimum wage limitations for men because men don't need special protections, but you can for women because women are weaker and they have to have special, solicitude of the law. So this paternalistic vision for upholding these progressive laws divided the movement in the way they describe. Now, Neil, tell us about how this division played out in the debate over the ERA in the 1970s. The ERA is introduced in Congress, it's moving along in the states, and the Supreme Court sweeps down and kind of enacts the ERA by judicial fiat in the Frontiero case in 1973, and some some historians have argued that this took the wind out of the sails of the ERA, and it was not ratified because the Supreme Court tried to impose it ahead of schedule. Tell us about that history and whether the Supreme Court was going ahead of popular opinion or tracking it.
Yeah, I don't think I would describe it as the Supreme Court via judicial fiat imposed the ERA, right? I think that the kind of framing assumes the conclusion that the Supreme Court did, right, what you asked about. In 1971, the very recent history is the first time in American history the Supreme Court strikes down a sex classification as violating the Equal Protection Clause. 1971 it's the year I was born. Very recent history. 1973.
Don't rub it in.
In the Frontiero case, right? You have 4 justices talking about the history of sex discrimination that women have endured in this country. Unfortunately, Justice Brennan not really emphasizing the framing and ratification of the 19th Amendment and the decades of social movement conflict over that. 4 justices in Frontiero say that sex classifications, facial distinctions based on sex should trigger what's called strict scrutiny, the most demanding level of judicial review known to constitutional law, where laws are presumed unconstitutional and governments have to have really compelling reasons to impose a sex-based distinction. There isn't a 5th vote in Frontiero, and some of the lore about the court is that there was a holdout thinking that the ERA at that point would be ratified. And a few years later, in 1976, the court, in a case called Craig against Boren, settles upon intermediate scrutiny, something between deferential judicial review and very demanding judicial review, in a case involving, unfortunately from my point of view, watered down beer. This was a case in which women had access to watered down beer in Oklahoma at 18, and men had to wait until 21, and that was the case in which the court declared that sex classification should trigger skeptical scrutiny. And I think a court that was more attentive to the 19th Amendment and the debates over the 19th Amendment and what it meant to give women the vote and why there was so much opposition to giving women the vote. The idea that women as economically dependent caregivers as opposed to breadwinners who participate in the public life of the nation, right? They didn't really need the vote. I think a court in 1976 that had been more attentive to that might have picked a different vehicle. They might have focused on something like discrimination against pregnant women as opposed to watered down beer, and they might have reasoned not just by analogy from racial discrimination, but actually from the kinds of sex equality norms that moved people to fight for the vote for women. I think it might have shaped the court's doctrine differently. Now, I haven't yet gotten to the question you asked, but Reva, I see you want to intervene.
I just wanted to, I thought this audience might find it interesting to hear just a little snippet more from the early 1970s. So we're describing, Neil is describing that the court shifted in the way that it was interpreting the Equal Protection Clause, and for the first time since the 14th Amendment's ratification, in the aftermath of the Civil War, the court began to say, distinctions on the basis of sex violate equal protection. But courts don't come to wisdom of this kind out of the blue. And the court, in interpreting the Constitution's text differently, was doing so at a time when there was enormous and increasing popular interest in issues of sex equality in the early 1970s, and a genuine move to press for ratification of the Equal Rights Amendment among them. But what I wanted to observe on the story of the 19th Amendment was that 1970 was the 50th anniversary of the ratification of the 19th Amendment. And the women's movement helped kick off the modern fight for the Equal Rights Amendment by essentially mobilizing on the anniversary of the 50th anniversary of the amendment's ratification, talking about the ways in which the suffrage amendment gave women equal voting rights, but not full equal citizenship. And so using the memory of ratification to raise a series of issues which the movement then in 1970 saw as necessary to secure genuine equality of citizenship for women. And what the movement then put on the table, that is in 1970 during the Women's Strike for Equality on August 26, 1970, was ratification of the Equal Rights Amendment, and then these three demands or talking points that came up every place that the celebration of the 19th Amendment's ratification was marked, and they were equal employment opportunity, equal access to abortion rights, which were then still criminalized, and national provision of child care services, so that the idea was that you wouldn't have full equality for women unless and until you altered the conditions on which they conceived and raised the children. That was as much a part of the meaning of equal citizenship for women as was voting itself proper. So I thought that story of this 50 years ago anniversary, the 50th anniversary would be an interesting piece of this story.
Can I just add very briefly?
Sure.
I don't think it's the Supreme Court that got out in front of the country, right, that had the perverse effect of causing the ERA to be defeated. I think there's a very powerful and effective counter-mobilization, right, led by Phyllis Schlafly, saying that if you pass the ERA, it's going to mean the end of any and all the sex distinctions in the country, right? It's going to mean the end of sex-segregated bathrooms, what Justice Ginsburg called the potty issue, right? It's going to mean all kinds of things that I think persuaded enough people. I mean, you had super majoritarian support in the country for ERA. You just didn't have super duper majoritarian support in the end, which is what you need to ratify our Constitution. It's extraordinarily difficult to do.
I want to return to contemporary constitutional implications of the 19th Amendment in a moment, but Nancy, Justice Ginsburg spoke at a wonderful National Constitution Center event in DC last week, and with riveting precision was telling the story about how she litigated the gender equality cases of the 1970s, first of all by often representing male plaintiffs who were discriminated against by laws that favored female child givers but not male ones, because she thought that would appeal to judges. To what degree was the legal victories of the 1970s, how much do they draw on the lessons of the 19th Amendment in focusing on political mobilization, and how much do they focus on winning the victories through the courts?
Well, I think that the two were very much in synergy. As Reva was suggesting, the advances that seemed to come very rapidly in the courts were ineffably, but definitely responding to the shift in social values, and they were responding to the pressures of a very vociferous women's movement. So that I don't think you can fully untangle those things. But I was very glad Reva mentioned those three demands of the Women's Strike for Equality in 1970, given that we really haven't achieved them all fully yet, 50 years later.
Well, let us focus on the constitutional applications today. So I began by saying some of the most exciting work in constitutional law today is being done by Reva and Neil and Nancy to argue that the 19th Amendment should be interpreted not simply as a guarantee of the right to vote, but a guarantee of gender equality more broadly. And Reva, you've written the definitive article saying that restrictions on the rights of reproductive choice should be viewed not only as a violation of the right to privacy, but as a violation of rights of gender equality. To what degree might the 19th Amendment play a role in arguing for a right to choose reproductive freedom?
So I guess the core issue here has to do with, the question of whether women have control, a voice in the conditions over which they become mothers. And the issue can certainly be understood as a liberty or a privacy issue, but I've also argued, this is an also, not an alternatively, also argued that it needs to be understood in terms of gender equality. That is, that there are certain forms of coercion in this sphere that carry forward the long tradition that we're talking about here in ways that are inconsistent with guarantees of equal citizenship today. There's sort of a choice of self-government, if you will, a choice to make family life as a matter, a sphere of equal participation and equal voice. And interesting question whether and to what extent this has anything to do with the 19th Amendment. I just told you a story about 1970 in which when the women's movement in the early 1970s was beginning to speak about equal citizenship, they articulated the importance of making equality mean in respect of family life. Not just the idea of avoiding family, but very, very much a question of what it would mean to participate as a family member in spheres of citizenship, whether it be politics, education, or work. So that's the childcare piece of this. I mean, I think it's totally fascinating to look at these two together, freedom to as well as freedom from. And at that time, the 19th Amendment was what it remains today, the sole piece of constitutional text that articulated a gender equality norm expressly on its face. We certainly can talk about the meaning of the 14th Amendment's Equal Protection Clause, but on account of sex is the language of the 19th Amendment. And so there was this nexus in the 1970s. I can also report to you that in the period before the court began to extend the Equal Protection Clause guarantees to women to protect them against sex discrimination in that early 1970s period, that there were advocates who invoked the 19th Amendment amongst other pieces of constitutional text when they were talking about reproductive autonomy. There in Connecticut, the litigation challenging a law that criminalized abortion with only, I think, an exception for a woman's life, the first opinion striking down that law also invoked the 19th Amendment as well as Title VII of the 1964 Civil Rights Act as grounds for understanding the equality norm. Today, we don't think about the 19th Amendment because when people talk about equal citizenship for women, they speak in terms of the Equal Protection Clause, and that's understandable. What the 19th Amendment does is tell us that in fights over women's equal citizenship, the way they do their family lives has played a central and continuing role. And so that, I think, is an important feature of how the 19th Amendment orients the story.
Neil, you too have done path-breaking work on arguing that the 19th Amendment should be at the center of rethinking some of our current constitutional doctrine. Tell us about how a 19th Amendment argument might support a right to choose contraception, for example. Also tell us the arguments on the other side, because I want the audience to get a sense of both sides. And have courts been sympathetic to this, to your arguments and Reva's? Has any court cited the 19th Amendment in rethinking these questions of reproductive choice?
Well, that last question is easy. As far as I know, the answer is no. I don't think.
One district court opinion, maybe from early 1970s, but
Yeah,
certainly not a norm.
Right. I thought you meant, say, last 20 years. Or I just want to be clear about what the claim is. The claim is not, if you just look at the 19th Amendment, Section 1, what you see there is right, a full-throated sex equality norm. It's as if all you need is the 19th Amendment and take it seriously, and the ERA has already been ratified, we just didn't know it, right? That's not the claim, right? I mean, the text is focused on voting, and it's focused on non-discrimination with respect to voting. I think the claim is that once you agree that the Equal Protection Clause of Section 1 of the 14th Amendment protects women too, right? The prohibition on states denying persons within their jurisdiction the equal protection of the laws, that women are persons too, and right, Justice Scalia, right, still contests that in various ways, but that is a deeply embedded constitutional norm. You're not going to be taken, well, you're very unlikely to get confirmed, right, if you say at a Supreme Court confirmation hearing that you don't think the Equal Protection Clause applies to women. I mean, Judge Bork, right, said that, and he did not get confirmed. No conservative nominee today comes anywhere close to saying that. That's, I think, how embedded the norm is. So once you agree that the Equal Protection Clause protects women too, the question is, what kind of sex equality does it have to offer? What does sex equality mean? And I think the claim is that the 19th Amendment and the history out of which it emerged is relevant to that understanding. Is sex equality just about classifications, distinctions based on sex?
Beer case, give
right?
the example
right,
of
the
beer
men,
case.
right. The men can't get the beer until 21, and the women can get it at 18. Or is it about the effects, the social meanings of different forms of government regulation, the gendered impacts, as well as forms of government action that reflect or reinforce the very kinds of traditional sex role stereotypes that made it so reasonable for so long for women to be denied the vote? If you imagine women as destined to be wife and mother, which is the way the court used to put it, as economically dependent caregivers, then it's not at all intuitive why contraception would be a very important constitutional right. Right? Women are supposed to be bearing children and raising them within the home, depending on their husbands for subsistence as well as representation in the outside world. But if you understand, right, that this claim about virtual representation, this claim about men are destined for a certain sphere and women are destined for another, that is defeated when the 19th Amendment is framed and ratified, then that seems to have implications for how we understand sex equality today. It's not just narrow distinctions or classifications based on sex. It's about firing a pregnant woman from work, right? And not being satisfied to say, well, that's just discrimination against a pregnant person. That's not sex discrimination, right? It's about reproductive choice, as Reva talked about it, which is not to say that reproductive choice is only about sex equality, right? It's also about sex equality. There are utterly good faith arguments for desires to protect fetal life, right? But if it was just about that, then you'd see a lot more support, right, for pregnant women and for mothers than we see in this country. It wouldn't seem like the costs of coerced childbirth are just modest in size and private in nature. It's only because we imagine that it's the natural destiny of women to become mothers anyway that we can rationalize coercing childbirth while denying the kind of social and material support that pregnant women and mothers need in order to raise their children and have a life outside the home, and so too, I think, with contraception. The Griswold case, and we're quickly coming to the 50th anniversary, the Griswold case, which protected a right of married couples to contraception and then extended a few years later to all individuals. This was before the court understands the abortion right. Decades before the court understands the abortion right as a sex equality right. Part of what Reva and I have been talking about lately is imagining this contraception right, which is defended as a liberty right, as an autonomy right, is also a sex equality right. That is absolutely essential for women to have access, safe, effective, affordable access to contraception if they're going to be able to control the timing of motherhood, right, and do so much more in the world than women were expected to do at the time it seemed utterly reasonable to deny them the vote.
Great. Well, we have a group of superb questions from the audience, and I'm going to jump right in. The first is, what relationship did race play in the framing of suffrage? Nancy.
Well, in the framing, it had little role. In the movement, I would say there were tremendous conflicts between white women about how far they might foreground and integrate black women into their struggle. It was rather a nasty business, I would say, in that, as I mentioned briefly, both African American men and women, the leading figures, the leading intellectuals and political thinkers, had actually been in favor of suffrage for women. And in the context of general disenfranchisement of black men in the South, where 90% of blacks lived, that was a bold and courageous step to take. At the time of fighting state by state, however, white women who led the fight in southern states were completely against admitting black women to their struggle. They felt that their strongest argument was that white women, if enfranchised, would outvote all African Americans. So there was a deep racist streak in particularly Southern women's strategies to gain the suffrage. However, that was not universal in the movement, and in New York, for instance, in New York State, there was some integration of the struggle, but it was generally a very bitter bitter experience for African American women who were genuinely for the vote for themselves and all women, and who found themselves marginalized in the movement, with only a very few exceptions.
Would proponents of the 19th Amendment be happy with the current status of women, or would they be frustrated with the lack of real equality? Reva.
Well, I guess I would say that with any of these kind of questions, it all depends. There are the fact that we're at a juncture where it's imaginable, at least, that a woman could serve as president of the United States certainly does represent a change over the history that we've been talking about here. And so in that respect, you could say that we've seen dramatic shifts in the political participation and leadership possibilities of women over the time period in question. The idea that there are 20 women senators now, I mean, that represents a shift that is dramatic, profound. It nonetheless remains the case that the traditions that we're talking about persist. And you could say it's great that there are 20 women senators. On the other hand, the proportions are certainly...
Why aren't there 50 women?
Exactly, right? So you could flip that. You can see, is the glass half full, half empty? You can see either dramatic change or persistence of the same story that we've been talking about. And I do think, and I'll just say this simply, that inequality is a lively thing. It changes shape over time. And so you can have a world that locks people in places of exclusion and subordination, a movement for challenging those arrangements, dramatic shifts, and still wind up with a world in which there's palpable differences of status and position between groups justified in new ways and in new forms. And I would say that's the world we're still in today. So.
What does it say about the Constitution's text that a sex equality amendment is today a political non-starter, Neil?
I think it says something. I think it says something about the work that remains to be done, and the half-empty part of what Reva just said. I also think it says something about unrealized or insufficiently argued possibilities for those who very much believe in sex equality in a very robust, substantive way. There's a story that Justice Ginsburg likes to tell when she's asked what part of the Constitution would she change if she could, and she says how she would, she'd want the Equal Rights Amendment to be ratified. She'd like her grandchildren to be able to stare at the Constitution and see explicitly what is actually there today more implicitly. And I think there's I'd like to see the ERA ratified too. And I think there's truth to what she's saying, but I also think that that kind of statement has a tendency to render the 19th Amendment invisible, right? There is a very important sex equality norm there in the text, and I think if we focused more on it and saw the interpretive possibilities that it provides, I think you'd see a more robust understanding of sex equality under the Equal Protection Clause as well as the Due Process Clause than we have so far.
I just want to add one thing, which is that women are half the world, and we're divided about what we think equal justice for women looks like and what the good society looks like and what our constitutional order ought to look like. And the fact that it's not possible to come to an agreement about these matters seems to be more likely than not. And so the fact that we couldn't just simply come to an agreement about what the Constitution ought to say and mean and be done with it strikes me as a healthy state of affairs in this society. We're debating exactly what it is that government can do for families and with families. And some of these things are so rudimentary that they actually ought to be ground norms of our constitutional orders. And others respects, they're great questions for us to argue with one another about in politics. And I think that's a healthy state of affairs.
Could you tell us about the woman who ran for president in the 1800s, Nancy?
Well, Victoria Woodhull is usually considered the first woman to run for president. In 1872, she did form a party and run. She was a very extraordinary character who came from very poor background, was quite an entrepreneur, actually ran a brokerage house on Wall Street with her sister, ran a newspaper of her own, and her running for president is only a very small part of what she did, as a matter of fact, and it wasn't a long campaign. She became later a spiritualist and a believer, an advocate for free love, and then later moved to England and became a Catholic. So she had quite a wild ride of her life.
There's a great book on her. What would you recommend for the group? Because it's fun to read about.
There are a few books on her, so I don't know which one you have in mind. Or
We'll
yeah.
send out a reading list afterward, but she's definitely
Yes.
worth checking out. We've got just, I think, 2 more questions, and then we're going to wrap up. Can workplace equality be achieved in a meaningful sense without legislation for adequate maternity and paternity leave? Reva.
Well, it certainly is the case that among Western industrialized nations, we do less to mediate or organize, sort of mediate work-family conflicts than, say, for example, European nations do. And it does seem fairly primitive or rudimentary that if we're going to make headway, we need to do more and do better than we have. But again, there are really interesting questions about the path to doing all of that. To what extent does the national government really move in some important way to impose requirements on employers? Watching our national conversation around healthcare, I could see that there might be some difficulties in going that route. But the notion that we need some basket of a menu of options, public and private, to make seriously, to impose in some sense, some forms of accommodation in the structure of work seems to me just an obvious thing. And the more change there is in family structure, the more this is going to mean something for men as well as women. It's not just a women's question.
And I would say, please, no just maternity leave, right? Maternity leave only, as opposed to parental leave, if you want to avoid perverse incentives not to hire and promote women, right?
Chief Justice Rehnquist wrote an opinion suggesting that having only maternity leave would actually violate equal protection. That's the Hibbs case.
And the FMLA pertains to both men and women.
For just this reason.
Yeah, we have national legislation that secures unpaid leave for employers of a certain size for certain grounds, and certainly including early child care leave. But it, as anyone who has a job knows, it does not wholly answer the question. And the question is, what are other ways that government, local and national, can move to nudge employers to change practices in a way that's more family-friendly.
Well, you know, I think my last question is going to be for some advice, and that is this to each of the panelists. How can the National Constitution Center and Vision 2020 best celebrate the anniversary of the 19th Amendment in the years leading up to 2020? Nancy.
Start a movement again for all these unfinished goals.
And I would say I just talked in too realistic a way about the work-family boundary. To pursue questions that are as disruptive, transformative, and utopian in our day as the vote for women once was in the mid-19th century. So.
And Neil, last word to you.
Well, there's a lot of talk about our Constitution in this country. The Constitution in politics often seems to be coextensive with whatever the speaker really likes or really hates. And I think there's a lack of and a real need for historically informed, even-handed, thoughtful, civic discourse about the Constitution. And you didn't pay me to say this, but when I think of groups like the National Constitution Center, I think about that kind of discourse. And so I would say more events like this, more events in which a variety of speakers with different points of view get together and talk about the 19th Amendment, talk about sex equality, talk about abortion, talk about contraception, and do it in a way that I think brings many different kinds of people together. Because one thing I've learned in my own life is that fighting for sex equality is not women's work.
Well, I know that Lynn and I are going to follow your advice and try to convene panels and exhibits and discussions as thoughtful as this one, but this is going to be a tough act to follow. You have been the gold standard and the dream team. Thank you, Reva, Nancy, and Neil.